Hey, it's Matt Erpelding, Vice President of Government and Community Relations for the Boise Metro Chamber of Commerce, back with part 3 of our series on the Families First Coronavirus Response Act. Part 3 focuses on the emergency family leave enacted by the law. This impacts companies with less than 500 employees and is available to employees who have been on the job at least 30 days. In this case, the employee can take up to 12 weeks by an employee who's impacted by COVID-19. Emergency leave through this program is different. Eligible employees may take leave if the employee is able to work and/or telework because they must care for a child under 18 years of age whose school or care provider is closed or unavailable due to a COVID-19 emergency, as declared by federal, state, or local authorities. The first 10 days in which an employee takes emergency leave are considered unpaid, but an employee may elect to substitute any accrued paid vacation leave, personal leave, or medical or sick leave, but the employer cannot require employees to do so. If an employee also qualifies for the emergency paid sick leave program, which we covered in part 2 of our series, they may use the emergency sick leave at the same time as the first 10 days of the emergency leave that would be otherwise unpaid. There's some issues around job restoration. Eligible employees who take emergency paid leave are generally entitled to be restored the position they held when they left, or the company must act to find an equivalent position as their employer. The Act does limit this rule for companies with fewer than 25 employees, and those will be clarified later on. There are a few challenges with this, and that is we're not sure how long COVID-19 is going to be present. We also know that the companies are going through a tumultuous time, but it's important to remember that this emergency paid FMLA is similar to the sick leave in that it is 100% reimbursed by the federal government against other payroll taxes or any other leave that is paid out. It's really important that when the person returns, that the employer makes every reasonable effort to restore the employee to their original position. And there are some statutes of limitations or limits that are applied to this, including a 1-year contact period, the date in which the employee no longer needs to take care of the child, and or 12 weeks after the employee's paid leave commences. We've provided more information for you below in the link below to help you figure out how you can best support your business and, most importantly, your employees during this tough time. And I know that this is a complex situation and complex legislation. I'll be back from my house with the CARE Act as it makes its way through Congress. I hope this is helpful, and I'll be in touch. Thanks again.